Hello there, this is Professor Nathanson. I hope you're doing well. Today we are going to talk about some basic tips on doing essay exams for civil procedure. This video is not aimed towards somebody doing their final exam. This is aimed towards somebody who may have never done any sort of IRAC question at all in law school so far. Certainly not in civil procedure. I think a lot of what I'm talking about here might help you in other courses. This is really just aimed towards civil procedure, so ask your professors from other courses what they have to say. If you go on my website, okay, nathanson.org, and you go to Courses, Civil Procedure, and Study Resources, one of the links will be for exam resources, and you can come here. I have all sorts of handouts, a few of which I'll talk about today. And I have some practice questions, some of which we'll talk about today. I also have prior exams. The ones that might be most helpful to students now, this is 2020, are my exams starting in 2016 and particularly 2018 when it switched to the Coleman casebook. I do have some of my selected prior exams from prior years on the website. But those are longer exams from when we did Civ Pro as 6 credits over 2 semesters. So they do take a deeper dive into the materials. I think they would probably be less helpful. The questions are also longer than the questions that I write these days. So I recommend look at these ones. I would caution you against trying to do final exam questions yet. Because right now it's only mid-September. You've only had some very basic stuff. My final exam questions, of course, cover a lot more ground, but also are written towards a higher level of performance. We're not aiming here today for the Super Bowl. We're aiming for preseason, right, for getting down basic skills. So what are those basic skills? Well, there's 2 skills that are attendant to doing well in an essay exam, and these are also kind of useful for when reciting in class. The first, of course, is just to learn the law. That's why you go to law school. But the second one is a little bit harder, getting it from your head to the paper. All right? Getting it from your head to the paper is a lot harder than it seems. You know, how many times does the professor call on you in class and you give the answer and you got the correct answer, but then when the professor asks you for the rationale, what is the reason for that answer, then word salad might come out of your mouth, right? You're not really able to articulate it. Well, equally so, knowing the answer in your head, because you've learned the law, that's the first skill, doesn't necessarily mean you can get it from your head onto the paper, right? So that's what we're going to focus on in this class. We're going to look at a very, very basic diversity fact pattern of the kind that you very well may know the answer to if I posed it as a hypothetical in class. But we'll see that getting it down on paper is not always as easy as getting it right when you're just asked yes or no in class. So here, let's look at this fact pattern, all right? Simple fact pattern. This is essay 1 from my handout of 2 skills, right? Which is one of the things that are assigned for this session and the links for which I'll put onto the YouTube. Here I have Deborah and Peter. Peter sues Deborah, right? But we don't even get there yet. Always start off with the call of the question. What's the call of the question? Is SMJ appropriate under Section 1332? All right, in Civ Pro, I'm always going to give you the call of the question, and it's always going to be narrower than discuss all Civ Pro issues. I would never ask you to discuss all Civ Pro issues. That's not an answerable question. There's too many issues that might be raised by a set of facts. Instead, I might ask you, is there SMJ? Or here I'm saying, is there SMJ under 1332, which is, of course, diversity jurisdiction. Now here we say if the authorities split, use the majority rule. This is intended to make sure you're using the domicile measured by indefinite intent to remain indefinitely, and not any of this permanent or for the time being stuff that you've seen in some of my other videos. All right, I'm really trying to cabin you into some basic IRAC. All right, let's look at this fact pattern. Peter sues Deborah. We're looking for SMJ under 1332. Once we've, number 1, read the call of the question, now we got to look at the facts. All right, we got Deborah sued by Peter, so we can have Deborah and Peter. Peter sues Deborah. What does Peter sue Deborah for? It is defamation. under state law in the U.S. District Court, Middle District of Florida, seeking $100,000, claiming that Deborah has damaged Peter's reputation and driven away all of Peter's clients. All right, so we got Peter versus Deborah for defamation under state law, seeking $100,000. All right, looking at this fact pattern, we know that we have to ask whether or not there's diversity jurisdiction, because that's what the question says to look at. Now we got to start thinking about spotting issues that are relevant to the call of the question. All right, it says that Deborah was born and still lives in Orlando. All right, that should tell us immediately that she's a citizen of Florida, U.S. citizen domiciled in Florida. That seems to be pretty straightforward. We see that she is alleged to have falsely accused Peter of embezzlement. Peter was born in Russia, but became a U.S. citizen in 2005, has lived in Manhattan, New York, near his law offices since 2002, and in 2000, which he visits a couple times a year. He plans to eventually retire there, and he goes to the condo every summer. All right, is SMJ appropriate under 1332? Well, let's look at the organized here. Now I've done a more detailed chart. Peter, born in Russia, 2002 moves to New York. 2005 becomes a U.S. citizen. 2009 gets a vacation home in Florida that he goes to in the summers, but returns to New York. He will eventually retire to Florida, though. Debbie, all it says, she was born and lives in Orlando. Well, based on this, you should very quickly recognize that this is a citizen of New York suing a citizen of Florida for over $75,000, and that there is, in fact, diversity jurisdiction. Maybe in class you can recognize that quite quickly. But can you get it down on paper that quickly? Well, let's think of tips and techniques. All right. IRAC we've talked about before. We talked about IRAC, FIRAC, and IFRAC. I'm not going to do that here. We've already talked about that in class. But remind ourselves, is IRAC the actual structure of essay exams? And the answer here is, well, yes. IRAC is the heart of legal analysis. For whatever issue or sub-issue you're addressing, you should be giving the issue, the rule, analysis, any counter-analysis, and the conclusion. But sometimes you have multiple issues, and sometimes an issue will have sub-issues. So the actual structure of any essay exam is going to depend upon the call of the question, the fact pattern, and the legal issues and sub-issues raised by both. All right? So you don't do pure IRAC. Don't ever give me an essay that just has 4 headings of issue, rule, analysis, and conclusion. Instead, your structure is going to depend on what issues and sub-issues are raised. This fact pattern, of course, has issues of amount and controversy, which appears to be met. It has complete diversity, but why? Well, one of the people was a foreigner who became a U.S. citizen, right? Is that relevant? Yeah, there's some issues there. Is the Russian citizen now a U.S. citizen? Yeah. Are they citizens of the state? Yeah. Why? We've got to analyze. Are they citizens of the state? U.S. citizen domiciled in the state. What's domiciled? So you see there's issues and sub-issues. And that's going to determine how you organize things. Even a simple essay question can have a whole bunch of issues and sub-issues. Well, Professor, you might ask, how about if I just lump all the issues together, all the rules together, and all the analysis together, and just have 4 headings? Issue, rule, analysis, conclusion. Can I do that? The answer is no, don't do that. It's going to be hard to write, be hard to read. You're going to miss a lot of issues. You're going to have lousy analysis, and you're not going to get a good score. If you're making sure you're hitting up the issues and sub-issues, you've got to organize it by issues and sub-issues. So what do? Your actual structure may include multiple IRACs and even sub-IRACs. Now let's illustrate that with the fact pattern we just saw. All right. Remember, we have an overall issue. Does the federal court in Florida have SMJ, really here diversity SMJ, in the suit by Peter against Deborah? And for the overall rule, don't give me every last little bit of law. Just give the main parts of the structure. Here, that's going to be amount and controversy and complete diversity, right? So it might be sufficient to say diversity exists for the parties if the plaintiff is alleging over $75,000, not including interest and costs, and there's complete diversity between all plaintiffs and all defendants, okay? And then, overall issue, overall rule, and at the bottom you're going to have an overall conclusion, which might here be, definitive. For the reasons stated above, there's diversity jurisdiction because the amount in controversy is over 75,000, and there is complete diversity between Peter and Deborah, right? But in other fact patterns, your conclusion might be tentative or contingent. If so, say what your tentative or contingent conclusion is, explain why, and why those contingencies might affect your conclusion, right? Well, you have your issue overall, rule overall, and conclusion overall, but then you have your sub-issues. We have two sub-issues here, AIC and complete diversity, all right? So for each sub-issue, you're going to have a sub-issue, sub-rule, sub-analysis, and sub-conclusion. And with a more complex fact pattern, you might have sub-IRACs. So again, IRAC is your kind of checklist for each issue and sub-issue. Are you hitting up all the stuff you need to hit up that's relevant to answering the question? But it's not a talisman. You don't give an essay answer that is just pure, here's the one issue, here's the one rule, here's the one analysis, or here's the one issue, here are all the rules relevant to this issue, right? Which could be 2-3 pages of rules. Imagine writing that. That's horrible, right? And so on. So here's our sub-issue number 1. AIC. Does a claim exceed 75, not counting interest and cost? And here, the sub-rule. You know, and not all the law that you've learned about AIC might be relevant to this fact pattern. This fact pattern doesn't involve aggregation, so you don't need to discuss it. This fact pattern doesn't involve valuing injunctions, so you don't need to discuss it. But you do need to discuss the legal certainty rule from St. Paul Mercury, right? We accept the amount pleaded by the plaintiff if it's made in good faith, unless the court is certain that it's impossible under the law, right? This legal certainty that it's impossible to go over $75,000, right? Articulate it clearly in your own words, right? But articulate it clearly. And then analyze. And here your answer should be that the amount in controversy is met, right? Paul, let's go back to the fact pattern. Paul was a successful, he was a successful international lawyer, right? And the alleged defamation drove away all of his clients. He seeks $100,000, but the amount in controversy doesn't require $100,000. It just has to be, it's met if the amount of controversy exceeds $75,000. $75,000 and a penny would be enough, right? So is it legally possible for Paul to get over $75,000? Yeah. Is he pleading good faith? Yeah. Why? His reputation has been ruined. All his clients are gone. If you're a successful international lawyer in New York City, in Manhattan, don't you think losing one big client could have more than $75,000 in business? I think, yeah. More pertinently, can you say it's impossible for Paul to get over $75,000? I think, again, the answer is clearly no, right? So is he pleading in good faith? Yes. Is it possible to get over $75,000? Yes. Is the amount in controversy met? Yes. So we go back to our outline here, right? Our sub-conclusion. Is the amount in controversy met? Yes, right? We move on to the next issue. Next issue is, are the parties completely diverse? Meaning that no P can be a citizen of the same state as an opposing defendant, right? Are the parties completely diverse? Well, here you should realize you're going to have two sub-analyses here, right? There's going to be one for Peter and another one for Deborah, right? I suppose it's easier to do if we do Deborah first, right? So we need complete diversity. You give the complete diversity rule. And then we must analyze Deborah. The law here is somebody's a citizen of the state if they're a U.S. citizen who is domiciled in a state of the U.S., right? Well, here, this is very easy, right? The fact pattern shows first that Deborah was born in the U.S., so she is a U.S. citizen by birthright. Regarding domicile, her birth domicile is Florida because she was born there and has always lived there. Domicile only changes when you set up residence in a new place, residence, and have the intent to stay there, majority rule, indefinitely, right? Well, the facts here show that she's never moved, so she maintains her birth domicile of Florida. And then since Deborah is a U.S. citizen who's domiciled in Florida, she is a citizen of Florida. Moving on to Peter citizenship. All right. Peter was born in Russia, right? He was born in Russia, but in 2005, he became a citizen of the U.S. In 2002, he moved to New York, where he also has his law practice, and he's still a practicing lawyer. So, you know, since he's been domiciled in New York since 2002, been a U.S. citizen since 2005. As of 2005, he is a citizen of the state of New York. All right? That would mean he's a citizen of New York. You have New York versus Florida. All right? So that would seem to be complete diversity. Now here you could have a counter-arg, CA counter-arg. Deborah might want to counter-arg that, hey, wow, first of all, Peter the plaintiff, he bought that vacation home in Florida. So therefore, he's domiciled in Florida because he goes to Florida every summer, right? That's a plausible but losing counter-argument. But it's worth raising because under the facts, there's a real question. Under the law of domicile, has his domicile changed to Florida? Because if his domicile's changed to Florida, then we got Florida versus Florida, right? But again, remember the rules here. All right? Paul, again, he's a citizen of the U.S. He was domiciled in New York as of 2002. Did his domicile change to Florida once he bought that vacation home in, I think it was 2009? And the answer is no. Even though he may reside from time to time in Florida when he goes there for his vacation home, it's not his main home. His main home is in New York, where he has his main residence and where he maintains his law practice. He always intends to return to New York. Whenever he goes to Florida, he does not intend to stay there indefinitely. He's only there for vacation, and he always intends to go back to New York. The fact pattern tells us quite clearly that he goes to Florida every summer and plans to eventually retire to Florida, okay? But we measure diversity as of the time of the filing, not based on a future plan to retire. His domicile will not change until he retires to Florida and has that residence combined with the intent to stay in Florida indefinitely. Therefore, the better conclusion here is that although Peter may go to Florida every summer, this does not affect a change in his domicile because he does not stay in Florida indefinitely. He always intends to go back to New York. Therefore, his residence has not changed from New York to Florida. He is still a domiciliary of New York who's a U.S. citizen. And since he is a U.S. citizen domiciled in New York, he's a citizen of New York. And since he's a citizen of New York, so he's a citizen of Florida, we have complete diversity. Now, let's go back to our outline here. All right, let's go back to our outline here. Remember, sub-issue number 1 was, is the amount in controversy met? And we concluded up here, yes. Sub-issue number 2 is, are the parties completely diverse? The answer is yes. So complete diversity is just sub-conclusion to issue number 2. It's only after you've done the analysis and the IRAC for issue number 1 and the IRAC for issue number 2 that we get to the overall conclusion. Because the parties are completely diverse, and because the amount in controversy exceeds $75,000, not counting interest or costs, therefore we have complete diversity for purposes of 1332. Therefore, there is SMJ under 1332A, specifically 1332A1, right? Boom. There you go. This is a simple fact pattern, but think of all the organization we had to do so we could head up all of those issues and sub-issues. And obviously, future fact patterns could be more complex with different or additional issues and sub-issues. So you could see just from the simple fact pattern, it's not as simple as just issue, rule, analysis, and conclusion. You got sub-issues, and you got sometimes issues within issues, and so on. So, outlining, should you do it? Yes, of course. Do subheadings help? Yes, absolutely. And use descriptive ones like amount in controversy, right? And complete diversity. And maybe another subheading for citizenship of Deborah, citizenship of Peter, and so on, right? Other quick headings, which we'll go over more detail sometime later. Argue the facts presented. Make sure you're not getting the facts wrong, all right? Don't change the facts. You don't get to do that. Don't add facts. You don't get to do that with one caveat. If after careful review, you conclude that additional facts are needed for your analysis, state what they are and how they would affect your analysis. But be explicit about it. Don't just assume additional facts that don't exist. Focus on the issue raised and don't engage in negative issue spotting, all right? If I ask you about SMJ, don't argue PJ, all right? If I ask you about SMJ and there's no federal issues there at all, then don't go down the path of federal question jurisdiction. You get no points for negative issue spotting. If you go really far afield, I might cut some points out. Don't be conclusory. Always give the because. Write legibly and grammatically. Do I cite cases and statutes? I can care less. I care that you give me the law. Giving me a number like, oh, see FRC P12. That's not the law, that's a number. Say, oh, see Penoyer versus Neff, or see International Shoe. That's not the law, that's the name of a case that contains law. You need to give me the law, not the name of the case or the rule or the statute that contains the law. All right, there's plenty more to say, but I want to keep this video kind of short. So I hope this helps. Make sure that A, you've gone through this, B, that you've gone through the handouts that I've given you, and then C, come on to the session and we'll take a deeper dive into some of the things we've talked about here. And finally, a moment of respect. Ruth Bader Ginsburg, Associate Justice of the Supreme Court. Take care, guys. See you soon.